volume. Good morning, everybody. Good morning. Good morning. Good morning. How is the volume, y'all? Hopefully, y'all can hear me. How is the volume? Let me know how good the volume is. All right. All right. Sorry about that, y'all. Oh, let me give me a drink of water. All right. So I'm not gonna be here long. I'm probably gonna stay about an hour. But I just wanted to talk about this because I don't get I don't get just an overwhelming amount of emails in regards to people asking me can I do their paperwork for them, but I do get enough to the point to where it is frustrating to me, and it's kind of starting to piss me off just a little bit, and I do apologize for that, but I try to make I try to make my experience, how should I word this, affordable for people. You know, I don't think the draft class that I'm holding, I think it's what's today? Today is the 14th. So the draft class is going to be on the 20th, which is next Monday. That's the day of the first class. It's going to be 6 classes. It's $200, I think altogether. I think it's 18 hours altogether because it's going to be a 3-hour class, and I'm going to do 3 classes a week. So yeah, I think that's 18. But I cannot draft your paperwork for you if you don't know what you're doing. I'm not. I don't know how many times I'm gonna have to say that. I think, and this is just my own personal opinion. Um, I don't think that makes me a good teacher, and I'm also of the opinion that that does not make you a good student. Because you pay me to draft this paperwork for you. I mean, that's it. You know, if you can't understand the contents of the paperwork, which in other words, if you can't understand the arguments that are being made in the paperwork, what was the point of you paying me for my time to draft this document for you? What's the whole point of it? Because if you get a hearing on this, which 9 times out of 10, you're probably going to get, either they're going to deny it without giving you a hearing, or you're going to get a hearing on it. Let's say they deny it without giving you a hearing. Now you're going to be like, well, what do I do next? You file an appeal, but you don't know how to file the appeal. So you're coming back to me like I'm trying to eliminate the dependency that most people tend to have on me, and I'm trying to make you independent. So you don't have to come to me for this stuff. So you can learn this stuff on your own. So you can draft your own paperwork. But I don't know, man. Like I think, let me check, because I think I have like 5 spots left in the draft class. I'm not really sure, but I think I do. Let me go and check right quick. Give me a second, y'all. We on. This gonna be Zoom. Let me see how many spots I got left. Oh, fine. Let me see. No meetings. Okay. So I'm going on Zoom right now. I'm just checking it out, y'all. Give me a second. Attachment draft class. 7 p.m. to 10, Monday, May 20th. Let's see how many people I got in this class. Registration. Okay, so I was wrong. I have two people registered for draft class. Two people registered for draft class, but only one of them has been approved because they're the only ones who paid me, the $200 for my time. So what that means is this one individual who paid me $200 is going to get, unless anybody else registers for the class, they're going to get 18 hours of me teaching them how to draft motions. And this is just you once you understand that all of this stuff is the same, it is going to make so much sense to you. We're not even going over any other motions. We're just going to focus on a motion to dismiss. That's the only thing we're going to focus on, unless I feel like that she or he is ready to move on to another motion. But all of the stuff is the same. It's all the same. The procedures might be a little different, but other than that, that's it. It's all the same. So back to what I was saying. I have two people who registered, but only one has paid me. As a matter of fact, I don't even think the one of them who registered, I don't even think they sent me a deposit. I don't even remember them sending me a deposit. So I don't know. I really don't even know who. Let me see who it is. Um. How do I find out? Give me a second, y'all. Try to figure this stuff out. Okay, I know who it was now. Focus. I'm just gonna call you Focus. I have not got your deposit yet. Um, it says you registered on the 22nd last month. I haven't got your deposit yet, but the last day to make the final payment is, I think it's the 18th. So that's 4 days from now. But I set this off for like a month. Like I did this like a month ago and gave people time. But I get it, y'all. I get it. If you can't afford it, that's okay. Or I also understand. And I also understand that if y'all don't know me, you want to get to know me before you send me some money for class and stuff. I get that and I respect that because there are scammers on here. People will run off with your money and they'll block you and ignore you and they'll lie on you. I get it. I get it. There are people on the internet that are like that. Fortunate for you, that's not me. But anyway, let me get back to this class. This stuff is it's easy, y'all. I don't know how much to stress that. It's easy. However, this stuff is mentally exhausting. All right. Because these people do not play fair. You might try to, let's say you're trying to argue that you have grounds to file an appeal that's out of time because the delay in which you file the appeal is through no fault on your own, meaning it's not your fault that you're filing an out of time appeal. It may take you weeks to find case laws on that if you don't know what you're doing. You know, take you hours. And then let's say you find the case law on it. Now you have to figure out how to argue the case. This stuff takes time, y'all. It takes time. And if you don't know how to draft your paperwork, then I'm going to, and I could be wrong, but I'm going to reasonably conclude that you don't know how to draft your arguments in your paperwork. If you can't do that, why are you going to send me money to do paperwork for you that you do not know how to argue? You don't understand it. No, you cannot pay me to do that. No, I'm not going to do that. You need to come to class. I can't do this by myself. This stuff is I have a headache right now. This stuff is extremely overwhelming. Uh, Let me see. Helping a friend with false allegations against them for a protection order. Friday they gave an appeal over the other party, lied to the court. Now they no state laws over. I showed them where to go. That's good. That's good. Good job, Robert. Friday I get paid to take the class. I need to know Zelle. I need to know Zelle. My bank just got this, so I am new to this. And also, Robert, I do want to apologize to you, but I don't want to. I need to get me a. I don't really have an address that you can send the. I know you wanted to do a cash payment. You know, I get it. But I don't have an address for it. I might just go and get another. Well, get a PO box in my business name or something like that, and we'll just do it like that. I guess for people who want to do that. I had a PO box in my business name, but I don't think it was really benefiting my business, so I just shut it down. But I might just go back to a post office somewhere and just open up another one. So I do apologize for that, Robert. But Zelle is pretty easy. I advise everybody to use Zelle because there's no transaction fee. They're not going to charge you for it. It's free. That's why I always tell people to use Zelle. I have tried paperwork in federal court, been denied discovery. You are right about the games. Yeah, man. Yeah, but just make sure you I would have to read the paperwork, Robert. Because sometimes if you don't follow the rules, then yeah, they'll rule against you. Okay, but there are cases in which you follow all the rules and they still rule against you. Because these people are biased against you. You're not supposed to know this stuff. You are not supposed to know what your rights are. That's why they always tell you, "Oh, I think you need to hire an attorney. I can't give you legal advice." What is legal advice? I don't even know what that is. Everybody has a right to practice law because everybody is presumed to know the law, and because ignorance of the law is no excuse. So you need to know what your rights are. And the only way that you're going to know what your rights are is you are going to have to read. The only way that you will know how to successfully draft arguments in any motion that you want to file in court is you're gonna have to read cases. Drafting like the capturing of the pleading, all of that's easy. The rule, the parties, the court, the name of the so-called court, the case number, that's easy. All right, that's easy. You can do that I can teach y'all that in less than 30 minutes. Or at least less than an hour. I should be able to teach the average man or woman that within at least an hour. That's easy. The difficult part is doing the research and understanding which facts that you need to use in your case in support of your argument. Because all of the facts, you're not going to need all of the facts. You're going to only need facts that prove your point. Do not ever, 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 ever say anything in any pleading that you file in court that can be used against you. I'm not telling you to lie, but do not say anything that can be used against you. Don't do that because they not going to do it. They commit due process violations all the time. But if you don't know what your rights are, how are you going to call them on these due process violations if you don't know what your rights are? How are you going to file a motion to vacate if you don't know what your rights are? You don't even know how to do the paperwork, but you want me to do it for you. And then you get a hearing on this and you go in there and you just mess it up because you don't understand your argument. You don't know how to argue the case. You don't know how to apply the case law to the facts of the case. You see what I'm saying? No, I'm not. No, don't do that. Come to class or at least watch the free videos on my YouTube channel. But I would advise you to just come to class because in the video I might not be answering. Well, in class too also. Well, no, if you come to class, then I'll know which answers that you need because you're going to ask the questions. I don't know I don't know what you don't know. I don't know what you need help with. Come to class. Come to class. Come to class. Come to class. I even like I accept installment payments on registering for this class. They're like when I did this, you could have made I'm gonna say I'm country or whatever. So that a lot of people say I'm country or whatever. You could have made four $50 payments and been good for class. It's only $200 and you're getting me for 18 hours. 18 hours to ask all of the questions that you need. And I intentionally limited the class to 10 people because I don't want a lot of people in there. It's quality over quantity for me. Um, I have a case that's already in the appeal court in Iowa. I asked a lawyer that was appointed to me in appeals if she would file a void judgment. A couple days later, got letters saying she doesn't represent me in district court, just appeals, but I want to file a void judgment. Okay. Um, what is the? Why do you believe the judgment is void, Levant? Five lawyers later, and they are all clueless. I can understand why people plea and are still in prison. Even innocent lawyers are lazy. Yeah, I agree with that too. Man, these people are all in cahoots with each other, man. This is a racket. It's a racket, and they all in cahoots with each other. I'm of the opinion that these people, I've heard of it, but I've never seen it. But I'm of the opinion that these prisons, along with they're doing some sort of business with the state in which they are required to keep these prisons filled, keep them stocked up. They're filled. The parole board. I think all of these people are in cahoots. This is a business. Statutes don't apply to me. Okay. Well, I don't have a call in number, so you can call in. But you said the statute doesn't apply to you. Well, I mean, if that's probably a due process violation if the statute doesn't lawfully apply to you, which is the same thing what they're doing with these driver's license and stuff like that. Telling you need a driver's license to travel, stuff like that. That's what the people were doing in that case I read not too long ago. Unconstitutional statute. Are you all right? So you're saying the statute is unconstitutional, or they are just applying the statute in an unlawful manner? Is that what you're saying? Which one is it? Because the reason why I'm asking is because the statute can be constitutional. I don't like using that word. The statute can be lawfully enacted, but applied in an unlawful manner. Meaning, they're just trying to apply it beyond the scope of which the legislature intended it to be extended. If that makes sense. Oh, they violated my rights multiple times. Well, um, you got to be careful now because if you don't raise objections to it, it's a timber buyer violation. I'm a little unfamiliar with that, so I don't really know too much about that. But when they violate your rights, they'll just say you waive them if you don't raise any objections to this stuff. So you got to be very careful. This is why you need to know your rights. This is why if you don't have a court reporter, then you need to probably pay for hire you a private court reporter to go in these so-called courts and get all this stuff on the record. I think they'll be less corrupt if that makes sense. If you have a court reporter. Have you ever seen Geo Group on annual reports on revenue and percentages of them paying federal agencies to fill their prisons? Headline here in Seattle, read during COVID, courts running out. Money was the headline. All the store I remember. I don't doubt none of that stuff, man. I don't doubt any of it because they are corporations. They're dealing in negotiable instruments. Okay, so it is on the record. All right. Well, what you should do, Levant, well, if you don't know how to draft, you probably just gonna have to come to class. I mean, I can tell you, um, but it might not be, I might not have all the, I don't know what you don't know. Put it like that. So I don't know how to, I can't give you answers to questions that I don't, that I'm not being asked, if that makes sense. I don't know. So I'm just going to advise you to either come to class or watch some of my free videos that that touch up on this. Watch the videos that teach you how to draft a motion and how to do legal research. I think those videos should give you an idea of how to start to do your research. Because the only thing that I do once I get like a new issue that I'm unfamiliar with, um, I study the law on it, the case law on it. I don't really too much care what the statutes say, unless well, no, I really don't care what the statutes say unless there's no case law um expounding or explaining or yeah, I'm gonna say explaining the statute. But I typically just read case law. That's what I do. It's a lot easier, and they tend to explain it a lot better than what the legislature has done. That's why I typically read statutes. I see what facts that are need to be alleged in support of whatever argument that we're trying to make, because it's always about the facts, so on and so forth, just like that. Just like that. I have all of the search warrants that were invalid since the magistrate judge was a certified law enforcement instructor. Well, I'm gonna tell you something, LeBron. It can be tricky now because they wearing a lot of hats. All right, they're wearing a lot of hats, so you don't know who you're dealing with. So there may be a statute that is authorizing this magistrate judge a power that is judicial in nature, despite the fact that that magistrate judge does not have any judicial power. You got to be very careful with these people. This is why you got to do your research. They're doing this everywhere. They're doing this everywhere. When a so-called municipal court judge sentence you or decides to issue you in a arrest warrant for your arrest, or a bench warrant, or fine you or something like that, if I'm not mistaken, based on the cases that I've read, those are all judicial powers. But the municipal judge is not a judicial officer. He's a member of the executive branch of government. They very tricky. Very tricky. So you got to watch these people. Um, why do you say the search warrant was invalid, Levant? As she states are under contract to pay if not enough prisoners are housed. I can believe that. I sure can. I can believe that, SG. Levant, sometimes these magistrates are part-time and they are vehicle accident lawyers. That's true too. Or in their private practice. Some of them be civil rights attorneys also. Some of them are the same attorneys who you going to see when your rights are being violated. I know because I had one sitting in on my case, acting as a retired so-called judge. They gave me a special setting. They called it a special setting, and it was just me, some police, and the judge. There wasn't nobody else in there. If you know what you're talking about, they will do that to you because they don't want people to hear what you're saying. They will do that. Happened to me. That happened to me one time, but there are numerous other times when I always went to court and they knew who I was. They called me last, and they waited until everybody else was out of the courtroom, and then they called me. That's what they will do. Uh, there's a PDF on magistrate and search warrants. inexperienced of all of them. They were thrown out. Okay. Um, my case, the detective sold their house. Sheriff retired early after I sent them a FOIA asking for bond. Detective left 120K on table to sell their house as soon as possible. Um, the sheriff does have a bond. Like in Alabama, their bonds are separate. I did a video on it. If you go on my YouTube channel, there's a video on it. They have bonds. The mayor has a bond too. All of these people, if they're required, if I'm not mistaken, if they're required to be elected by the people, they have bonds. They have insurance. That's really all the bond is their insurance. Um, but they do have them. The sheriffs in Alabama, they have their own separate bond. They're not covered under the blanket bond. That's in Alabama though. I don't. It may be different where you are, Robert. Uh. Anyway, man, look, y'all gonna have to come to class, man. I know, like it might be some people like, well, he only just want money and blah blah. Blah. Like $200 is, in my opinion, that's cheap for 18 hours of my time. That's cheap. 10 people, 18 hours of my time. You get one-on-one time with me. You get screen share with me, and then all of you gonna get you're gonna get the video because I'm gonna record it too. Everybody who attended the class is gonna get the video for free. Because I mean, I'm not gonna make you pay for that. You already attended the class, so that's gonna be free. But if you didn't attend the class, and you want to pay for it. I think $100 is reasonable. I think that's affordable for 18 hours. I actually think that's cheap, to be honest with you. But it is what it is. Um, there'll be so essentially it's gonna be like 6 videos for, is it 6 videos? Yeah, because it's one, two. Yeah, it's gonna be 6 videos for $100. I might just sell them $25 a piece or something like that. It is. I think. I don't know, I think $25 a piece is. I think that's reasonable for 3 hours. Yeah, I think $25 is affordable. So I might just do them $25 a piece or something like that. Let's see. Do you teach how to collect with travelers? Because I never got any letters back from their insurance. You talking about travelers insurance? If you're talking about that, I don't really know too much about it, to be honest with you. What is, I don't even know what travelers insurance is. Is it just like to travel, like just for insurance when you're traveling over the country or overseas or something like that? I gotta order me something to eat. I ain't ate nothing. I'm hungry. At the store, I remember money was the headline at the store. I remember. It's always about money, man. It's always about money. That's just like with that child support thing. Let me see if I can go on my channel and find that. I'm trying to make it happen, but funds are tight at the moment. I'm not worried about getting robbed by you. I sent you an email. Okay, appreciate it. Cool, man. Appreciate it. I'll check it out when I get offline. Sold my house, gave one lawyer 30K who did nothing, no communication, no discovery, signed my name on a plea. Oh wow. When was this, Robert? You need to sue him. I would sue him. Now it's gonna be difficult because when you suing these people, his buddy's gonna look out for him. The bar is gonna look out for him. But I would sue him or go after. I would try to find his bond or whatever. You could probably get his bond information through discovery because I'm sure he has insurance or some sort of bond. Uh, did nothing, no communication, no discovery. Signed my name to a plea. 200 is nothing, and I am broke in debt. I'm sorry to hear that, Robert. Ooh, I'm sorry to hear that, man. Travelers is what all these state agencies go through. I found out for insurance in Washington State. Okay, they let's see, they probably thought you would put a lien on them. Man, if you can draft a motion, you can sue somebody, man. Because the only thing you're doing, you're going to apply the same principles. What principles am I talking about? You're not going to say anything in your complaint, just like you're not going to say anything in your motion or petition that can be used against you. You're not going to talk about anything that's not relevant. What I mean by that is you're not going to talk about anything in your motion, your petition, or anything you file in court that cannot be used in benefit of you. If it does not serve the purpose of your argument, don't talk about it. Just act like it ain't happening. And that's the story that you stick to, the story that you typed up in your complaint. Because all of the other stuff, if it was relevant, it would have been in there, but it's not relevant. So we're not talking about it. We're gonna act like it didn't happen. That's irrelevant. We're not gonna talk about it. You can file a motion with the court, to get me to get the judge to order me to do it or whatever. But until that happens, I'm not gonna do it. Like I had to force the police officers who I sued in my case, their attorney, he kept giving me the runaround about their financial information because I wanted to know, their financial information because I'm asking for punitive damages. So I want them to come out of their own pockets, and to pay me in punitive damage or whatever. But their attorney, he just flat out told me after just giving me the runaround, I'm not giving you my client's financial information. And I was like, all right, and that was it. And then I filed a motion to compel. I think I filed. I don't know if it was a motion to compel or it was something because I was asking for it in discovery. And I think we had to, it wasn't a motion to compel. We had to file position papers because there was a dispute, and we're required to, pursuant to our Rule 26 conference, to try to resolve any disputed matter that we could in good faith before bringing it to the court's attention. And anything that we couldn't resolve, then we had to take it to the judge, and he would make his ruling based on the arguments that we were making. And long story short, he ordered the attorney to give me his client's financial information, and he did. They signed affidavits. Of course, they could have been lying about it, but they signed affidavits and stuff like that, showing me this stuff. I still got all this stuff it's on my office desk, in this office desk right now, sitting where my computer is sitting. You are right, and I found out OIG sleep in the same bed as the lawyers. So you are right. It's a club from Article 1 judges, the lawyers, to the marble toilets. I agree. I agree, man. I'm watching this series. It's only 2 seasons, but it's a series called what's the name of that series? For Life. It's called For Life. And they're giving you some background of the politics of how these people get down and so forth like that. And also it's that's a good series. It's only 2 seasons though, but they're they're men in there, they're in prison, and some of them are getting caught with contraband, they're getting caught with stuff that they shouldn't have in prison. And so but they have to have a trial on this before they can get punished. And so in the episodes, they're having administrative trials in prison, the same thing that they do in these so-called courts. They're having an administrative trial in there. They're presenting their exhibits. They're not really making expressed objections. In other words, what I mean by that is they're not saying the word objection, but they are making objections. The police officers are acting like they the judges. The warden is sitting in there acting like a judge. Like that's what it is. Stuff like that. because that's what they're doing. Z, what's good, Z? I mean, yeah, Steve, what's up? If you haven't already, I think helping people understand what relevant facts are for their complaint is critical. I completely agree with that. The fact a lot of people don't know this, Steve, but I've told them this. I don't know if they've been paying attention to the videos, but the facts are the elements that you need for your cause of action. The facts are the elements that the state needs to prove to convict you. It's the same thing. The facts are the ingredients that you need to make a valid cause of action or a valid criminal charge or whatever you want to call it. You know what I'm saying? It's always about the facts. Always. Understanding the difference between facts and conclusions also important. Well, you can't have conclusions without facts. Not no reasonable conclusion. It can be a conclusory conclusion, but it's not going to be reasonable. I got to go to the barber shop. I got hair. I need a haircut. Uh, J. Embry and get a clue to new channels. I found they are right about parallel construction, how they gain evidence against the person. The Coburg case in Idaho proves he is innocent and a cover up. Yeah, they'll do that, man. In that series that I was just talking about, For Life, it's about this black man. He was a club owner, and I don't want to give y'all too many details, but this black man, he's a club owner, and he was accused and convicted for being a drug kingpin or something like that. And but he was innocent though, and so he wasn't an attorney before he went to prison. He became an attorney, started helping inmates in prison and stuff like that. And he fought his own case and he won. He got a retrial. It would after he got granted a retrial, but the state I think attorney general or something like that, they gave him clemency. I think it was clemency or they exonerated him or something like that. And he got his life back. You know what I'm saying? But I would have sued them people. I would have sued them. Judge denied jury instructions of the definition of timber buyer. Yeah, so that definition probably was critical to determining if it was if you were, I'm assuming, guilty or not or something like that, or I'm assuming if the statute lawfully applied to you or not, meaning if it was, that definition was material, if that makes sense. It was a determining factor in which could sway the jury to either rule for you or against you, if that makes sense. I'm assuming that's what you're saying. Uh, oh boy. In business or personal use. Uh, Example, I was illegally arrested while on the sidewalk. All right, that's a good example, Steve. The first example is that's a conclusion. I mean, that's a conclusion. That's what I tried to say. That's conclusory. That's what police officers do 99% of the time. That's what they do. They don't have facts in their complaint. They only list conclusions. And you should, when they do that, you should motion to dismiss because the complaint fails to charge an offense. It is devoid of the prerequisite elements of the charge, and it fails to charge an offense. You need to motion to dismiss. They do that all the time. All the time. That's what they do. The second one versus I was standing on the sidewalk waiting for a ride. Police approached and demanded ID. I refused. I was arrested. Just like that. Believe it or not, Steve, that is literally how simple It is to draft your complaint. Your 42 section 1983 complaint, that's all it is. But people don't understand this stuff. Now, of course, you might have to go into details a little bit more, I would advise, but that's right. That's right. You can look at everything you just said. I was standing on the sidewalk waiting for a ride. Police approached and demanded ID. I refused. I was arrested. You can read all of those facts and reasonably conclude that that was unlawful. And no police officer is going to get qualified immunity or any form, they're not going to get immunity, period, based off these allegations in this complaint. They're going to get denied immunity until probably after discovery. Or they probably settle the case after discovery. That's how simple it is. It's just that simple. It is literally just that simple, y'all. That's a good explanation. That's a good example, Steve. Because it's literally that simple, y'all. It is just that simple. The conclusion doesn't state a claim. Exactly. It doesn't, Steve. It does not. It does not. The conclusion doesn't state a claim. The facts state a claim. A lot of people don't know this. The only thing that you're doing, y'all, when you're filing your lawsuit is you right then, like when you're drafting your complaint, you're just making allegations. That's all you're doing right then and now. You're just making allegations. All right. After you make these allegations, their attorney and the judge is going to look at these allegations and they're going to determine if these police officers are entitled to any form of immunity before they allow you to go through discovery. Meaning, if you plead facts that show a clearly established constitutionally protected right, of which a reasonable officer would have known about, has been violated, they're not going to get immunity, y'all. They're not going to file no motion to dismiss, because if they do, their ass is going to lose. They're going to lose. Because when you file a motion to dismiss, you're not disputing the merits of the complaint. You're saying that they didn't state a claim. That's what you're doing. And you can't dispute facts in a motion to dismiss, because that's the improper standard to do it by. I think it holds more weight in front of a jury when you tell them you are being denied discovery by the prosecution versus asking for it, but you have to have proof through certified. I'm thinking certified mail. I think that's what you tried to say. I would agree with that, Robert. The problem with this stuff is they don't really want juries to see this stuff. They play. I hate to say this, but I'm just gonna go and say it because it's the truth. Jurors are innocently stupid. They are innocently stupid, and they are gullible. They want people like that on the jury. They don't want people who know what's going on the jury. They're not gonna. If you know what's going on you're never gonna be placed on a jury. They're not gonna do that. Father in exile, post Ninth Circuit Court of Appeals, where immunity is denied. I'm litigating a case right now, based on numerous fabrication of evidence claims. I'm assisting somebody with that. These police officers, they don't have no immunity in this case. They blatantly lied, and then they went out of their way to lie and fabricate this evidence. No reasonable officer would have done that, because a reasonable officer knows that that is the violation of a clearly established constitutionally protected right, because you cannot fabricate evidence. No reasonable person would do that. No reasonable person would do that. No reasonable officer would do that. A reasonable officer gets granted immunity. An unreasonable officer gets punitive damages, and they lose their case, like they should. I don't even agree with the whole qualified immunity because I think I don't think police officers um should be able to claim qualified immunity. I don't, because qualified immunity is a common law um form of immunity, which they just made up. But I mean, most of this stuff is just it's based on principles too. But most of the stuff is just made up. But police officers they're not created under the jurisdiction of the common law. Only the sheriff is. The sheriff should be able to claim some sort of qualified immunity or discretionary function, something like that, some form of common law immunity. But I don't think police officers deserve that. But anyway, y'all, I'm gonna get out of here in like 15 minutes. Y'all come to class. 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 Because I don't know what you don't know, and I can't help you if I like. I don't know. I don't know. Just come to class. But I do understand, money tight. I get it. I get it. That's why I only said $200, and you're getting 18 hours of my time, and it's gonna be recorded. I'm gonna do a lot of screen sharing. I'm gonna do the best that I can to make y'all understand this stuff because it's not hard. But the most important thing that you're gonna have to do is read. That's what you're gonna have to do, and you're gonna have to do. I'm gonna tell you what's gonna help y'all, man. Learning how to do legal research and reading. That's all you got to do. That's how your arguments and your vocabulary are going to get better in this particular field. Because I know mine is, and mine is a lot better, a whole lot better. Let me see if I can. I want to try to show y'all one of my arguments. Damn, it ain't on this computer. Let me see if it's in my email. Hold on, y'all. Let me go to my Google Gmail. What um I forgot what I was looking for, y'all. I forget. Damn, what was I looking for? I don't know. I forgot what I was looking for. I think I was looking for a document to show y'all. Let me see if I can find one. Okay, let me see. Let me see if I can find something. First Amendment complaint order dismissal. Let me see. Well, I want to wait to this case is finished being litigated right now. So I don't want to make it public right now. I want to see if I can just show y'all some of the objections that I was making. See if I can show y'all something without showing y'all something, without giving too much away. Let's go down. Objection. I don't think this is it. What is this? Oh, okay, okay. So this is just a little different. Let me see something. Yeah, this is like a rough draft. Okay, this is a rough draft. What I was looking at. So I'm trying to just show y'all something. But this way it's not finished. So I ain't gonna show y'all that one. Objections, rough draft, judicial notice, affidavits, search warrant. Is this? Uh, that complaint I did, y'all, for the guy who got the fabrication of evidence claims. It's only 15 pages. 15 pages. But it's on point. It's on point. They can't deny any of this stuff, but they're trying to. They're trying to dispute these facts in a motion to dismiss, and they can't do that. But anyway, let me go back to the chat. I'm gonna wait till the case is over with before I do that. At least I disagree when it's used as intended. An officer who is acting in good faith should not be personally liable for a violation. I disagree with that because you can't say you acted in good faith, in defense of you violating some statute. I disagree with that. Equality under law is mandatory. Everybody's entitled to that, and everybody's presumed to know the law. So now we don't. Now, ain't none of that. No, you got to hold them to the same standards that you hold us to. You're a police officer anyway. How you going to not know the law the so-called law that you are attempting to enforce on people? You don't even know it. Then you're not even abiding by it. No, that's inequitable. You need to be fired. An officer who is acting in good faith should not be personally. Okay, there's another one. The standard of fact review in the light most favorable to plaintiffs should make IQ easy to remove when there are violations. Yeah, I do agree that it is improper when the course when the court uses a tougher standard for the plaintiff. Um, they're deemed to know the law with previous Supreme Court case laws, thus no qualified. I mean, I agree with that. Everybody's presumed to know the law. Ignorance of the law is no excuse. So now they need to be held to the same standard. The same standard. An officer who is acting in good faith. The people just need to nullify this stuff, man, because they can whenever they want. You don't have to wait on your state legislatures to do this. If you don't want, if you want to list qualifications for any police officer or sheriff or whatever to be entitled to some form of immunity, you can do that, and you don't have to petition your government to do that because the Constitution, it doesn't prohibit you from doing that. You can change that Constitution at will whenever you want, but they're not gonna tell y'all this stuff because they want you to think that the Constitution applies to you when it doesn't. The Constitution does not say what you can and cannot do. It says what they can and cannot do, not you. All three branches of government are administrative agencies of the people. They belong to the people. The law that they are administering is the Constitution. In other words, IQ was not IQ. I'm so dyslexic. I'm sorry. I'm looking at QI and still saying IQ. But anyway, in other words, qualified immunity was intended to prevent frivolous claims, requiring a showing of a prima facie case that there's a real the state. There's no burden for the state for to prevent them from filing frivolous claims and lawsuits against people because they do that all the time. The state do it all the time, especially in traffic court. In traffic court, they're allowed to make conclusions in traffic court. They're allowed to make conclusions in traffic court. The reason I say, if you look at your traffic ticket complaint and look at the facts. I know in Alabama, based on the traffic citation that I've seen, it says something like defendant was unlawfully operating a motor vehicle, other vehicle, or something on this street at this amount of time. But they're not qualifying these definitions. And then there are no recent court opinions that are strictly construing the scope of these ordinances and these statutes. In other words, they're not telling you where these statutes are applicable and where they aren't applicable. They are always talking about when you're talking about you're not driving, you're traveling, they want to call you a sovereign citizen and all this. Let me tell y'all something, man. Give me a second. I'll be right back. Yeah, SG. That's what they call it, a reasonable mistake. A reasonable mistake. That's in that I think it's Haynes versus North Carolina, something like that. I think it was decided almost 10 years ago. They want to call you names, call you a sovereign citizen and all this because they don't know any other way to commit fraud against you because that's exactly what they're doing. You do have a right to travel. I'm not telling you what I think. I'm telling you what I know. They're not going to tell y'all this stuff. Not today, especially not during today's era. They're not. How you doing, free game? The draft class is $200. You need to come to class, free game. If a cop violated a statute, he is not acting in good faith and should not be granted qualified immunity. I mean, he doesn't even have to violate a statute. If he's violating case law, which is the common law, he's not entitled to immunity. Yeah. But this is what they do, man. This is what they do, y'all. So I don't know what else to tell y'all, but this is what they do. This is why you need to know your rights. Draft class is $200. The deadline to pay for the class. I mean, I did this like a month ago to give people time, but the deadline is the 18th. It's going to be a 6-day class, Monday, Wednesday, and Friday, 1 week, and Monday, Wednesday, and Friday again. The next week, it's going to start at 7 p.m. It's going to end at 10 p.m. And I think altogether it's about 18 hours, and we're going to record the class. So make sure when you come to class, bring a pencil, paper, and just ask a lot of questions. If I know the answer to the question, I'll give you the answer to the question. If I don't know it, the next time we come to class, I'll try to have the answer for you. The facts of the complaint of my charges, they said the facts were from the Miranda's interview and that the evidence was suppressed, so that should make the complaint null. I'm kind of a little confused, Levant. What you mean by that? The facts of the complaint of my charges, they said the facts were from the Miranda's interview. Okay, so I'm assuming that they must have interrogated you or something like that, and that the evidence was suppressed. Okay, so that should make the complaint null. Okay, so I'm assuming they either violated maybe the Fourth Amendment or maybe the Fifth Amendment, and as a result of that, they suppressed any type of evidence that could be used against you. Is that what you're saying? I think that's what you're saying. Yeah. But back to what you were saying, SG. They're allowed to make reasonable mistakes. But let us come in there and try to argue something like that. A reasonable mistake. Yeah. He's full of it, man. I ain't never really read no case explaining. Well, I haven't even been looking for one, to be honest with you, though. So I can't say if it was or if it wasn't. But a reasonable mistake in regards to where somebody like us can use that as a defense, as an affirmative defense. But that's really all it is. It's an affirmative defense. Not if they could acquire information from the interview from other sources. Okay, I see what you're saying, Levant. Uh, okay, I saw your email. You say you want me to call you. What do you want me to call you for, Levant? If you don't mind me asking. Don't take that the wrong way, but I'm just curious. Oh boy. Let me see. I really be want to show y'all some of these documents, but I got these cases, they still pending, so I don't want to risk it because I have haters on my channel and they might come in and they might look at the phone numbers on here and start calling these attorneys and saying, hey, you need to go and follow this guy on YouTube. He's talking about this case. He's helping so and so with this case and blah, blah, blah. This. We ain't got time for that because there are some haters on my channel that'll do that. So that's primary that is primarily the reason that I'm not disclosing the name of the case, where it's being litigated. I'm not discussing nothing. I'm very vague when I discuss it. Where it at? None of that. Not doing none of that. Okay. Well, I'm about to get off here, y'all, because I was only going to do an hour. But before I leave, if you haven't, uh, register for draft class, and I would really appreciate it if y'all went ahead on and joined my jurors membership. It's 99 cents. Just go to my YouTube channel. Let me show you where you can go to it at. Cause am I screen sharing? I don't think I'm screen sharing. No, I'm not screen sharing. All right. So you can go to my profile page on YouTube. Click join. It'll be at the top next to well no, just click join, and then there'll be 3 forms of memberships down that you can join or whatever. Also, I still do offer 42. I still do offer classes on 42 Section 1983 lawsuits. If anybody needs it, I do private consultations also. Via Zoom, it's 1 hour. It's $100. These are one-on-one consultations. Hour. The video is recorded, so you can get the video. Like I'll Dropbox you the email. I mean, not the email. I'll Dropbox you the video once it's finished processing, and I'll send it to you via Dropbox. So that's it, y'all. I'm tired. Let me get on up out of here. I will see y'all in class. Whoever registers for class, I'll see you in class. Um, excuse me. What is it? Next Monday at 7 p.m. Central Standard Time. Everybody enjoy your day. And Supreme Litigant is out, man. Let me get on up out of here. You can challenge them if they use other information from the interview to develop the alternative sources. Fruit of the poisonous tree. Yeah, typing sucks. Man, look, I type a lot, Levant, and I mean a lot. Anyway, let me get on up out of here. All right, I'm gonna call you when I get off, man, Levant. I'm gonna call you. Give me like 10 minutes, and I'm gonna call you. Everybody enjoy your day. Peace. Supreme Litigant is out.